We see the ground of the jury's all present and accounted for.
We are back on the record in C-377239, State Nevada versus Devin Michaels. May the record reflect that Ms. Michaels is present with her attorneys, deputy district attorneys on behalf of the state, and both parties stipulated to the purpose of our jury.
Yes, Your Honor.
All right. Ladies and gentlemen, we have now reached the portion of trial where closing arguments will be given. Since the state has the burden of proof, the state will get to begin and close the closing argument. State, are you prepared to give your closing argument?
Yes, Your Honor.
All right, whenever you're ready.
The truth is the truth. It shouldn't change. And the truth is, the walls were closing in on Devin Michaels and the fantasy that she had put together. And what was her response when her children were taken away? Jonathan had custody, and this was in danger. She did the unfathomable. She murdered Jonathan Millett. The crime charged in this case is murder with use of a deadly weapon. We heard from the judge. She did read that to you folks prior to our break. So what it is willful, unlawful, felonious, and with malice aforethought, the defendant killed Jonathan Millett, a human being, with use of a deadly weapon, to get a wooden stick and or an unknown object by striking the said Jonathan Millett with the said wooden stick and or other unknown object and or through other unknown means. The said killing having been, one, willful, deliberate, and premeditated, and or second, committed during the perpetration or attempted perpetration of a robbery. Let's start with the easy one, the deadly weapon. You heard from the defendant that she hit Jonathan Millett with a stick, and he died. So this is clearly showing that that stick that she described to you is a deadly weapon because it resulted in the death of Jonathan Millett. Now I want to point out something very important that's in your instructions, and it's not something to gloss over. The state is not required to have recovered the deadly weapon used in the crime in this case. So keep that in the back of your mind that we are not required to do that. However, we have the confession from the defendant that that is what she used. So that being said, you'll have your verdict form when you go back to deliberate. So I think it's helpful to sort of walk through that. So based on knowing that there was a deadly weapon used beyond reasonable doubt, we're able then to eliminate guilty of first degree without use of a deadly weapon, and also guilty of second degree murder, and guilty of voluntary manslaughter. So all that we are left are those charges with use of a deadly weapon. Let's talk about murder. Your instructions tell you that murder is the unlawful killing of a human being with malice aforethought. Whether expressed or implied, the unlawful killing may be effected by any of the various means by which death may be occasioned. So let's talk about malice aforethought. What does that mean? That is the intentional doing of a wrongful act. So I don't think anyone is going to get up here and say that this was not a brutal first degree murder. Knowing that, defendant's actions were not voluntary manslaughter. Voluntary manslaughter is the unlawful killing of a human being without malice aforethought, without deliberation or premeditation. It is a killing upon a sudden quarrel or heat of passion caused by a provocation sufficient to make the passion irresistible. That is not what we have in this case. The defendant said in her statement to the police, told the police, that she was giving Jonathan a back massage while he was laying face down on his bed. She was next to him. She got up off the bed, made the conscious decision to then walk over to that fireplace that we all saw, grab what she described as a candlestick, an object, right? Walks over, makes a conscious decision to then walk over, goes to the bed, and while Jonathan is still face down, with his head facing away from her, as she told us, she took that stick and bashed the victim in the head. He had no clue that this was coming. Conscious decisions every step of the way. His body goes limp. This is not voluntary manslaughter. The instruction also tells you if there should appear to have been sufficient time for a cool head to prevail and the voice of reason to be heard, the killing shall be attributed to deliberate revenge and determined by you to be murder. The defendant did mention that the victim, Jonathan Willett, had rubbed on her leg. And then she kind of just chewed it off. It was like, okay. And then after that, he seemed happy, right? His face was turned away, thought he was getting more of a massage. But instead, the defendant made those conscious decisions that I just went over and bashed him in the head. This is not voluntary manslaughter. So that being said, when you go back to deliberate, we'll have this form again. We've already crossed off the ones that don't apply, so let's cross off the other one. Voluntary manslaughter with use of deadly weapon, because no one's going to get up here with reasonableness and say that this was voluntary manslaughter. So then what are we left with? First degree murder. You were instructed that murder of the first degree is murder which is perpetrated by means of any kind of willful, deliberate, and premeditated killing. What are those three elements? Willfulness, deliberation, and premeditation. And I do have a graphic photo here, so I just want to warn everyone, including in the gallery, that there will be a graphic photo. This is first degree murder. What is willfulness? Willfulness is the intent to kill. There needs to be no appreciable space of time between formation of the intent to kill and the act of killing. What is deliberation? Deliberation is the process of determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action and considering the consequences of those actions. This is very important, and I am going to spend some time on this. A deliberate determination may be arrived at in a short period of time. The best way to illustrate this is the stoplight example. So all of us drive to work, we're on our way to work, and there's a stoplight. And sometimes that stoplight turns yellow. And when it's yellow, you're making some conscious decisions at that point, right? Either you're taking the decision to press on the brakes, but during that you're deciding, well, is someone going to rear end me, right? If I just stop on my brakes, right? Is my coffee that I just bought from Starbucks going to fly all over the car and I'm not going to have coffee at work if I slam on my brakes? Is my purse going to fly off the seat and I'm already running late for work? So how am I going to have time to put all the items back in my purse so I can walk into work? If I press on the brakes, I'm going to then potentially be late for work. And I've already been written up a couple of times, so this may be the time I'm fired. All of this is going on in your head when you're faced with that yellow light. You're also thinking, well, I obviously can't press on my brakes, right? So I'm going to have to go through this light. But what are you thinking about when you're going, making the decision to run that yellow light that's about to turn red? You're hoping there's no cop, right? You're hoping that a motorcycle doesn't come out from nowhere and you hurt someone. There's no bicyclist that's just somehow hoping that you're going to stop at the red light because they see that it's yellow. All of these are conscious decisions that you're weighing, and that is all deliberation in a short period of time. We do it every day. Again, it need not be for a day, an hour, or even a minute, this premeditation, this decision making. It may be as instantaneous as successive thoughts of the mind. The stoplight example. No matter how rapidly the act follows the premeditation, it is premeditated. That is what happened in this case, when the defendant made each conscious decision ending Jonathan Willett's life. We also have another theory of first-degree murder. That's called felony murder. There are certain kinds of murder which carry with them conclusive evidence of malice at forethought. Therefore, a killing which is committed in the perpetration or attempted perpetration of a robbery is deemed to be murder of the first degree. So what is a robbery? You of injury, immediate or future to his person or property, or the person or property of a member of his family. Such force or fear must be used to, 1, obtain or retain possession of the property, 2, to prevent or overcome resistance to the taking of the property, or 3, to facilitate escape with the property. We heard a lot of evidence over the past 2 weeks, which is why I'm slowly going through this today. We have evidence that the defendant took multiple items of Jonathan's belongings: social security card, a wallet, his only set of car keys. Why did she want those things? How is she going to enroll the girls at school without having Jonathan's documentation? This all goes into her motive. The defendant obtained Jonathan's property by means of force or violence, i.e., she killed him, and took his wallet, his only set of keys, and his social security card. This is another easy one. That being said, you'll have your verdict form. And between both theories of murder, we are confident that you'll be able to check that first box and at this point eliminate the second-degree murder. But that being said, any way you look at this case, this is first-degree murder. And this is important to note, because when you go back there, you're doing an important thing. But what is also important is that while a guilty verdict must be unanimous, you need not be unanimous on the means or the theory of first-degree murder in arriving at your verdict. What do all those words mean? That means when you go back there and you're carefully weighing the evidence in this case, if 6 of you decide that the state has proven beyond reasonable doubt the felony murder theory, and 6 of you decide that it's the premeditated deliberate, that doesn't matter. The verdict would be guilty of first-degree murder. You need not be unanimous on the theory of first-degree murder. So there's been a lot of talk over the past 2 weeks about Devier, and we're not shying away from this. You saw him testify on the witness stand. There is overwhelming evidence beyond what he told you that Devier did not murder his father. Let's go through that. We'll start with Devier's testimony under oath. He tells you that he saw his father, Jonathan Willett, at that Porcupine Rim address, the house that he and Devin shared, briefly on August 6th. You'll recall that he saw his dad in the garage and just went right back inside. They never had a discussion. And he was home at the Porcupine Rim address on August 6th. He told you that he was helping the girls, his sisters, Devin's daughters, with homework. The defendant, Devin, tells him that she's going to help John move some things. He goes on about his night. He stays at the house, he watches a movie with the girls, he puts them to sleep. This is what he's telling us. He goes to sleep around 10 p.m. He woke up, he recalls around 2 a.m. to see Devin getting in bed, which they shared at that time, and he just went back to sleep. He woke up at 6 a.m. the next morning on August 7th. He gets dressed, he goes to work. Even if you don't want to take his word for it, which we believe you should, we also have other evidence to corroborate what Devier told you. This is a text message that Devier sent to the defendant, Devin Michaels, where he texted her, "See you when you get back. I'm going to sleep. Girls are in the living room," corroborating that he put the girls to sleep and he was going to sleep as well. This was on August 6th, 2023 at 10:36 p.m. We also have video surveillance to corroborate this. No video surveillance shows Devier's vehicles in Caladura's neighborhood, Caladura being the murder house neighborhood. No vehicles belonging to Devier are seen. And we spent a lot of time going through that video surveillance on that lengthy data trial, showing you that there is no indication that Devier's vehicles are in that neighborhood on the night of the murder. There's no video surveillance showing Devier's vehicles entering or exiting Porcupine Rim neighborhood, the neighborhood he lives in with Devin. Remember that fixed camera? There was no indication that his vehicles left that evening, or entered for that matter. Devier's vehicle was in the same position overnight. You recall there was sort of that catty corner home that had that footage showing the daytime and the nighttime, and the van, Devier's van, remaining in the same position to a T. There's also no video surveillance showing Devier jumping a back wall to get in another vehicle. There is no evidence of that. What we do have is Devier leaving in his work van at 7:31 a.m. on August 7th, because that's what happened. We also have the CDR mapping, which also rules Devier out beyond his work. If you recall, there was that Detective Good testified pretty in depth. He had color coded the different phones so that you could see with ease which phones were popping up at which times. You recall Devier's was green. We see green popping up at that Porcupine Rim Street, which is his home, throughout the night, and more importantly, during the time period of the murder, which we'll talk about later, because we are able to narrow that down. At no point do we see Devier at the murder house the night of the murder, and even more importantly, during the murder. Again, I explained this, I just want to show it. This is that footage of the nighttime. We see, if you recall, up in that top right corner, we see the victim's truck, Jonathan Willette's truck. We also see right next to it, Devier's work van. This is the night of August 6th. This is the next morning of August 7th. There's that same work van, Devier's work van, in the same position. Nighttime, daytime, nighttime, daytime. Never changing. Physics also ruled Devier out. A lot of discussion about how he jumped to that wall, he took the road that's one house over that, not the road, but the little dirt path, right, to get all the way across town. 7.5 hours? No. That's not common sense. I also think it's important to highlight Devier and the defendant's relationship, Devin's relationship. Devin is a master manipulator, and that is shown through the evidence. This is a woman in her late 30s that decided to begin a sexual relationship with her 19-year-old stepson, who had just lost his virginity. I'm not going to get up here and say that the 19-year-old teenage boy, this wasn't his dream to be with Devin Michaels, who was an older, more sexually experienced woman. But what I am going to say is that the defendant is the one running the show here. This was her fantasy, and he went along with it for a while, though. Because remember, he tried to move away to California on multiple occasions, and somehow she was able to stay in her bed and bring him back. The most glaring portion being when she uses a supposed pregnancy against Devier to bring him back to Las Vegas. When she threatened him, I will have this baby and tell everyone whose baby it is if you don't move back to Las Vegas. So what does young Devier do? He moves back to Las Vegas. He doesn't want a kid at his young age, and even complicate his relationship with his family that doesn't know about their relationship or their sexual engagements. There's also messages that show that Devin was in charge of this relationship. He tried to get out multiple times. So now that we've talked about this could not be Devier, let's talk about who's on trial today. Devin Michaels, the defendant, and how there is overwhelming evidence that she committed first-degree murder. I'm going to go over a roadmap of all the different evidence that you heard in the past 2 weeks and sum it up as much as I can. We'll start with Yoko Yoshida's testimony, Devin's inconsistent statements, so her own words, the scene, the DNA, the burlap, which we heard about today again, CDR mapping, video surveillance, the phone contents, and we'll also talk about the custody case and those witnesses we heard yesterday. I think it's very important to start with the timeline because, as Mr. Giordani said, this one's a wild ride and we have to buckle up. So let me start with the timeline here. The timeline starts August 6th of 2023. Devin, John, the girls, they're all shopping for the girls' first day of school. At 8 p.m., Devin arrives at the murder house in her vehicle, and Yoko confirms this. At 8:42 p.m., Devin, the defendant, and John drive to Devin's home. At 9:40 p.m., Devin and John drive back toward the murder home. 10:04 p.m., Devin and John they get to Chevron. They're there for a few minutes, as we saw, and then return back to the Palo Duro neighborhood at 10:12 p.m. And that's even confirmed by Yoko saying that she saw Devin and John, and that's when John began to prepare a meal for himself. At 11 p.m., a person places something in the Nissan Armada, Devin's Nissan Armada, moves the Armada in front of the murder house. And what's notable about that, and I think it's important to highlight, is it went from being in front of the camera to being out of the camera, but more importantly, closer to the house, right in front of the driveway, and nose to nose with Jonathan's truck, which we see was in the same position the next day based on the surveillance, as well as the testimony from officers in this case. We then turn to August 7th, 2023. At 1 a.m., Yoko runs into Devin for about 15 minutes or so. At 2:04 a.m., Devin leaves the murder home in her Nissan Armada. At 2:39, she's at that CVS drive-thru that we saw the surveillance video for. And then at 8:40 a.m., there is that 911 call from Jonathan's mother when she discovers her son dead. We can then safely say on this timeline that the murder that Devin committed occurred between 10:12 p.m. and 2:04 a.m. So knowing this time frame, we're able to look at the corroborating evidence. Let's start with Yoshida's testimony. The day before the murder on August 6th, he sees Devin at the murder house. And more importantly, he also saw her vehicle at Aladura. We heard from Yoko. Again, around 8 p.m., Devin arrives at Aladura in her Nissan Armada. Devin and John then leave in John's truck. Around 10 p.m., Devin and John return to Aladura. Yoko sees them. After seeing them, she goes upstairs. At 1 a.m., she goes back downstairs. She runs into Devin, and what did she describe to you? Devin looks surprised. Why? Importantly, Yoko also says that the light was on in John's room. Of course, you also heard that the way the bed was situated, you would have to walk into the room, down, and go around to actually see the bed. But regardless, she sees that the light is on in the room. Devin tells her that John started drinking and he went to bed. Yoko told you that she didn't hear anything from John's room. The light was on. Didn't really think anything of it. And that she and Devin talked and washed dishes for about 15 minutes. Because that's when Devin told her that Jonathan, the next morning, was going to meet her with the girls, and they were going to go ahead and go enroll the girls at school and take them to school. She confirmed to you that there were only 4 people at the home. Yoko, Yoshida, Devin, and the victim, Jonathan. At 1:15, she goes upstairs. She goes to sleep after having that conversation with Devin. Around 2 a.m., she wakes to the dogs barking in the backyard, and if you'll remember, that was abnormal. The dogs, when John was asleep, or at night in general, were not in the backyard. So why were they in the backyard barking? She also heard a thud. She then goes back to sleep. At 8 a.m., she goes downstairs, sees John's truck is outside, which is a little weird because Devin had told her that the plan was for him to already be gone by that time in the morning to go enroll the girls. So her antennas were up a little bit. She calls him, calls John, he doesn't pick up. Prepares her coffee, goes back upstairs. She called him again, no answer. So now her senses are heightened even more. So she goes back downstairs. She looks around John's room, couldn't see him, because again, the bed is around that corner, as you saw in the photos. She then goes upstairs again. After going upstairs, again, feeling even more heightened concern, she goes back downstairs. And it's at this point she goes deeper into John's lower room, a makeshift bedroom. She sees the doggy door is down, and the dogs are still outside, abnormal. She saw inside the garage door, inside garage door was half open, the one leading into the garage, abnormal. The big garage door was open as well, as you all saw in the photos. It had an opening there, abnormal. So then she investigates more. She goes to his bed, and she sees John wrapped in a blanket. She opens the blanket, and she saw feet. She then goes around to the other side of the bed and sees the amount of blood that's on the other side. Goes upstairs, tells Yoshida, they call 911. Devin also made several inconsistent statements. The truth is the truth, it should change. What were those inconsistent statements? The first one, Jonathan's engagement ring. If you recall in interview 1, Devin tells the officers, we threw his engagement ring in the trash last night. Okay. Interview 2, threw away John's engagement ring. We kind of made a joke of it, 2 points, threw it in the trash type thing. So it should be in the trash, right? We saw pictures of the trash, of multiple trashes in the Paladura address. Not just one, but multiple. 1, 2, 3, 4, 5. None of them containing a ring that were searched by officers. Ladies and gentlemen, there was no ring that was thrown in the trash. Inconsistency 2. Her marriage to Debbie Ayer. We learned from interview number 2 that this was a marriage of convenience, not intimacy, which we know is not true based on other evidence in the case. Interview number 3. Her marriage to Debbie Ayer is just on paper. Rings aren't significant. Me and Deb haven't been intimate in years. That's not true. Inconsistency 3. The gun safe. In interview number 1, Devin tells officers, we took the guns last night, but we didn't bring ammunition because there's no safe at my home for them. Ladies and gentlemen, we saw pictures of a safe. There was a gun safe in the home. There's a close-up of it there. And there's guns and ammunition. Gun safe in the home. No safe. Inconsistency 4, Jonathan's wallet. In interview number 2, she tells officers, John lost his wallet yesterday. He leaves stuff around a lot, minimizing. Then we have interview number 3, which is after the search warrant of Porcupine Rim, where they start to confront her with the fact that there's Jonathan's items in there, more specifically his wallet. She tells them, at first, nothing of John's is in my house. John's wallet wasn't at his house, so do you know where it is? No, sir. I have all of his old driver's licenses. The license you found is an old one. We know that's not true. I tucked the wallet away in bags. I knew, but how would she know that the wallet was wrapped in bags in her underwear drawer? She wasn't confronted with that. Nothing of John's in my house. There was. His only set of car keys, his current driver's license, his wallet. And what was found inside her purse? Jonathan Willette's social security card. Why would she have those things? But nothing of John's at her house. Again, the license he found is an old one. And if we look here close up, it expired November 7th of 2025. The murder happened August 7th of 2023. This was his active driver's license. His old one. I tucked his wallet away in bags. Remember, ladies and gentlemen, this wasn't one bag. This was 8 bags, and you heard in the interview with Detective Weinoff that were tied over and over and over and over again. Not just one bag. What was she trying to hide? Also, how would she know? Inconsistency 5. Where was John? In interview 1, she tells officers that John was in the garage, awake, smoking when she left. He was smoking when Yoko came down. But remember, Yoko said Devin told her John was sleeping off his alcohol. So which one is true? She says she said goodbye to him, pushed out a box under the garage, went out the front door. Then the next interview, last thing she did with John was pop his back. He went to smoke. She talked to Yoko. She finished loading. He told her what to take, and that was it. All inconsistent, and not the same story. Inconsistency 6, John's bloody phone found at Devin's home. There's a lot of discussion about this during the trial because it's important, and it shows that Devin committed the murder. And why? First of all, she told us in interview number 3, he told me he cut his hand, right? He said he was moving a table and one of the parts fell and took a chunk of his hand. She offers this to police. I didn't see it, but I do know he mentioned bleeding on his hand. Very descriptive. Then interview number 3, he must have been smoking and set his phone down. Again, no notifications are found on John's phone, as if someone manipulated it. Because as we know, John was called and texted multiple times, especially when people were trying to find him. Why would he have no notifications on his home screen? That's because the phone wasn't left by John. We know that his blood was on the phone. And we know that it arrived after the murder based on those CVRs. Based on that raw data, we know when John's phone made it to Devin's residence. And that's when she took it there because, as you know, it traveled with her after she committed the murder back to her home. This is also an important one. She tells detectives that it was dark in the room and she couldn't see when she committed the murder. In interview 4, we finally get her confession. She hit him. And that's when we get the details. But she tells us that she couldn't really see what she grabbed off the fireplace because it was dark, but she could see him breathing. She tells the detectives, because they're a little confused by that statement, because you can't describe the object in her very hand, but she's able to see Jonathan breathing. She tells him, well, your eyes can adjust. And remember, Yoko said the light was on in John's room when she came downstairs. It wasn't off. It's also important to note that he was wearing boxers. He had his boxer briefs on, she tells the police. And we know that's not true. The boxers were found at the foot, next to the side of the bed, as shown right here. She also can't really account for the time after seeing Yoko at 1 a.m. And this one's really important. In interview number 4, she initially tells detectives, well, I wasn't there for an hour after Yoko came down. That's not true. But then she's confronted that no, there is evidence that you were in fact there until 2:04 in the morning. So detectives trying to solve this case for the family is asking, what were you doing? What were you doing in that time frame? She remembers every detail before. She remembers every detail after her interview. But she doesn't remember this time frame. Why? Because she did it. She was decapitating Jonathan. I can't remember. I remember talking to Yoko, getting my stuff, leaving, going to the pharmacy, and going home. But she doesn't remember the time frame that she was decapitating Jonathan. Why? She's told this has got to be eating you up. And this is why videos are so important. This is her response.
This is gotta be eating you up. This is gotta be eating you up.
She's nodding.
This is gotta be eating you up.
This is eating her up.
This is gotta be eating you up.
Ladies and gentlemen, she admitted to the murder. She said in her interview, when she confessed, that she took that object, the stick, the wooden stick, and bashed Jonathan in the head. That is the murder. But there was a head missing, and that was important to the detectives to give closure to the family. So what about the decapitation?
Well, you have to have somebody put out a report that's where you were in the house. That's it. That's the only time you don't remember.
I didn't know you said that long.
It doesn't matter if you know.
It doesn't mean I don't remember being there that long. I didn't know I left.
Okay, so the possibility you did it, you don't remember?
Yes, sir, it's very possible.
Okay.
Yes, sir. It's very possible. The scene does not lie. Defendant can lie, but the scene can't. So what's the hard evidence as well, in addition to her statements that are inconsistent, other than the confession? As we know, John was found on his bed, and there was bleeding. And we also noticed that there were 2 blood spots specifically. on that sheet that he was wrapped in. One on one side and one on the other, as you can see in that right-hand photo. She rolled him to the edge of the bed to complete the decapitation after she had realized she murdered him by hitting him, as evidenced by the 2 blood spots that we see there. In that last interview as well, there was a drawing, there was a diagram, there was a sort of a back and forth a little bit with the defense talking about that the detective was the one drawing, but I will leave it up to you to sort of see how that was going down. Devin drew that line there, and the detective told her multiple times, correct me if I'm wrong, is this where you were, where the X is? Yes, that's where I was. She drew him in the exact position she left him in. There's some truth. The DNA can't lie. We heard that Jonathan's cell phone was found at Devin's house during that search warrant of the Porcupine Run residence. And we heard from CSA Nicole Merriam, who testified twice, that she swabbed that blood spot right there on the phone, and the testing revealed presumptive positive for blood. It also revealed Jonathan's blood. It's also important to note that Jonathan's blood was found in the driveway of the residence. We have that marker A, which you can see there, the blood spots with the cone. And we also have marker B, which was that Jonathan's bed frame, where they saw those droplets of blood. All Jonathan's blood. It also is interesting where these blood spots are, because they're in the driveway in the same exact place Devin would have walked to go back to her vehicle to drive home, as we know occurred at 2:04 in the morning. Devin's DNA is on that knot of the plastic bag containing the wallet and John's only car keys. They also tested inside and outside of the wallet, including all the pocket openings. So the inside of the wallet also contained Devin's DNA. This wasn't Jonathan dropping it in a bag. Why would Devin's DNA be inside the wallet? Devin and John's DNA are on his social security card swab. Not shocking that Jonathan's DNA is on his social security swab, or social security card, I should say. But remember, this is Devin's bag. You see her wearing it in the surveillance video with the chevron. She also described it to police during one of her interviews. And what's found inside is that social security card belonging to Jonathan Millett. And not only is it found, but it's found with the defendant's DNA on it. She handled it. She wanted to enroll the girls at school and knew that she needed documentation because the father of the children was dead. We also heard from the coroner, Dr. Duggie. The cause of death, homicidal violence. The manner of death, homicide. The internal exam, and this is important, decapitation occurred post-mortem. Jonathan was decapitated by the defendant after she bashed him with a stick and killed him, based on the science. No one's disputing that, not even Dr. Sims today. This is also important. No bleeding injuries on John's hands were found. None. She did discuss slippage, which she explained what that was, where, after death, the skin tends to shed a bit in different areas. But again, no bleeding injuries on John's hands. Then we had testimony from Dr. Burns, who passed around those cool exhibits, Cass, I should say. And she explained that there were 2 implements used to decapitate the victim. As you can see in the picture there, this is her annotated version showing that there were 2 implements that were in fact used. A hand-powered serrated or non-serrated knife was the first. Then a mechanically powered saw, because it's very difficult to cut through human bone. Not only did Dr. Yagi and Dr. Sims agree today, but also Dr. Burns told you that the impacts that she saw on the neck were consistent with post-mortem dismemberment. Jonathan's head was decapitated after he was murdered. There's a lot of discussion during trial about whether it's possible for a woman to do this. I think it's important to note, as Dr. Burns highlighted, a mechanical saw is made for anyone. Women can do anything, especially ones that have a clear motive. Moving on to the Burla. Where was Devon's vehicle during all of this? Her Nissan Armada shows she's at Paladura during the time of the murder. We have at 11:05 p.m., there's that short activation that we saw on the Burla, which I'll go ahead and play for you. And it is not very long. It's at 11:05 p.m. on that August 6th, 2023, which is corroborated by the video surveillance where we see her vehicle moving up right in front of the driveway of Paladura, nose to nose with Jonathan. Then we have 2:04 a.m. This is when Devon's Nissan Armada leaves. And we saw that in the Burla. She goes from the Paladura address, she goes to CVS, then she returns home to the Porcupine Rim address. I won't play this all for you, you'll have this back in evidence. You've seen it during the trial. We also have that call detail record mapping. Where was everyone's phones during all of this? More importantly, where was Devon's phone during this? And we had Detective Good testify that the defendant's phone was at the murder scene when the murder was occurring. And what's also interesting to note, which you kind of have to get close to see, but there's sort of this blue dot that is now traveling with Devon's red device all the way back. And this was at that 2:04 in the morning. So that's how we know that the victim's phone was taken by Devon back to her home, because we have that Google geofence highlighted by that blue dot there of Jonathan's phone, showing when it actually got to the Porcupine Rim, and that's when Devon got it. We also heard phone content evidence, which demonstrates Devon's intent in this case. I worry as much as you probably won't believe. I miss us. I'm glad you appreciate what we once had. We will have it all again, Jonathan says. I want our family back. We got to do as great as we can for the girls to have a good life. The walls were closing in. We have the video surveillance that was played for you in depth during trial. And there's some important notes from that. We saw how much video surveillance was canvassed in that Paladura neighborhood. There was a point where the detective even said, you can pinpoint the address that I needed him to because of all these contacts. Then we have that next door residence to the murder house, that 2696 Paladura Drive. Again, next door. And this is that video I talked about earlier where we do see the Nissan activated and we see it move in front of the driveway of the murder home, 2698 Paladura. We also see in this vantage point of the video when Devon and the victims returned home from that trip from Chevron. When they were coming from Porcupine Rim, stopped at the Chevron, got some items, then came back, and we actually saw those shadows of two figures, which would be Devon and Jonathan, getting out of his truck to go inside of the Paladura residence. This camera gives us that as well. And again, 11:05 p.m., we get that activation, and we see that the Nissan Armada is moved up closer to the residence. Why would she want to move it closer to the residence? She's concealing her crime. Then at 2:04 a.m., we also get from this residence that the Nissan Armada leaves, putting sort of a bookend on the timing of the murder. We then have the video surveillance from the Chevron. We've also called it the Terrible Herbs. And in there, I talked a little bit about this. We have that they're there at 10:10. That's Jonathan's truck pulled by a trailer. They then leave at 10:11 p.m. And we know that Yoko, as well as the video surveillance from the Paladura neighborhood, they're arriving into that neighborhood around 10:12 p.m. All corroborating. giving us our time frame. We have the video from the CVS pharmacy, the drive-through, 2:28 a.m. on August 7th of 2023. This is after the murder, where she's at CVS. Again, giving us a time frame. There's no one in that vehicle but Devin. You can see with your eyes. We then have the 6621 gray Juniper surveillance video camera from Devin's neighborhood. This is that one that was fixed where you could see the only entrance and exit of the Porcupine Rim neighborhood, and it was constantly running. We were able to see different things from that. Remember, it was 3 minutes slow to real time, but accurate. At 8:57 p.m., we have John's truck entering the neighborhood. And this is on August 6th. Then at 9:29 p.m., John's truck leaving the neighborhood, further corroborating the timeline. Then importantly, at 2:39 a.m. on August 7th, after the murder, we see Devin's Armada and Devin returning back to her residence. At no point was Devin or Devier's work truck or that sedan seen entering or exiting. Very important. We don't see his work truck or any of his vehicles leaving until 7:31 a.m. on August 7th. So now let's talk about Devin's motive and intent, which is very important to consider. We heard from individuals that knew about the child custody case during this trial. And they told you that Jonathan had been given full primary physical custody of the two girls, Tamaya and Janaea. And this happened on October 27th of 2022. So at the time of the murder, Jonathan technically still had full physical custody of the girls. He had something he could hold over Devin's head. The walls were closing in on her. We also heard from Elizabeth Lemons Woods, who also had worked on the child custody case and sort of the placement of the girls after Devin was arrested. She meets with Devin on August 17th of 2023. She wants to tell the defendant, hey, heads up, I just want to notify you, the girls are being placed somewhere else because you're not there, and their father is no longer around. And what Elizabeth Lemons Woods testified to is that defendant then started giving her more information, more than the scope of what the original conversation was supposed to be about. And what I think is notable is that Elizabeth says that throughout the conversation, Devin appeared that she was trying to cry. Why would you try to cry? Devin said during the same conversation, she had to do it. She had to do it. Now, ladies and gentlemen, it's very important, and you're in fact instructed on this, to use your everyday common sense and judgment as reasonable men and women. Do not check your life experience and what you know to be true at the door. Bring that with you when you deliberate. The evidence in this case is overwhelming.
There's Mayor now, huh?
I told you from the beginning I did.
Is that how you feel against him?
It's hard, and Mr. Giovanni hit the nail on the head when he said, buckle up, this is a wild ride. This is unfathomable, but this is what happened. We are confident as the state that having all of this evidence in front of you, that you are going to go back to that jury room and you are going to check guilty of first-degree murder with the use of a deadly weapon, because the defendant committed first-degree murder under both theories: premeditation, deliberation, and also felony murder. Thank you.
All right, ladies and gentlemen, we need a moment to set up the technology for the defense's closing argument. We're going to take a brief recess. During this recess, you must not discuss or communicate with anyone, including fellow jurors, in any way regarding this case or its merit, either by voice, phone, email, text, internet, or other means of communication or social media. You must not read, watch, listen to news, or media counsel commentary about the case. You must not do any research, such as consulting dictionary, using the internet, or using birth materials. You must not make any investigation, testing theories, any recreating an aspect of the case, or any other way investigate or run the case on your own. You must inform or anything regarding the case of time to you. Ladies and gentlemen, 2 o'clock will be in recess till 2:15.
All rise for the jury. Please be seated. Your Honor, the jury is all present and accounted for.
We are gonna go back on the record and see 377-239 State of Nevada versus Devin Michaels. Waive the record, plaintiff Michaels is present with her attorneys. Deputy District Attorneys on behalf of the state, we both parties speaking in the presence of our jury.
Yes, Your Honor.
Okay, Mr. Gossett, you prepared for your closing argument?
Yes, Your Honor. Thank you.
We'll be back.
Thank you. This case is entitled State of Nevada versus Devin. Proof beyond a reasonable doubt is the highest standard in the American justice system. It shows an adoption of a belief that he took from the old common law from England, that it's better to let 10 guilty men go free than to wrongfully convict an innocent person. I would also submit to you that it shows a belief and an understanding from the founding fathers that very few people have the resources, the opportunity, or the ability to prove their innocence. You've seen that through the course of this trial. You have officers come in, collect evidence, and officers are people. I'm not going to stand before you and say this officer's a bad person. We talked about it through jury selection. But officers make mistakes. People are subject to biases, to confirmation bias, where they reach a conclusion first and then kind of work backwards. And I would submit to you that that is what happened in this case. And our founding fathers understood that. And that's why they placed the burden upon the state and the state alone to prove its case, each and every element of its case beyond a reasonable doubt. I'd like to talk a few minutes about the jury instructions. We had a few technical difficulties, but you all have the same packet. I'd like to discuss just a few of these instructions. I'm not going to tell you which boxes to check. You're smart. You paid attention, very close attention throughout the entirety of this trial. You are the sole judges of the facts. You alone will decide what will happen to Devin Michaels. Instruction number 3 talks about murder with use of a deadly weapon. And that's what the state wants you to convict her of, first degree with use. But the pleading document is telling. Instruction 3, it states, murder with use of a deadly weapon did willfully and lawfully, feloniously, with malice aforethought, kill Jonathan Black, a human being, with use of a deadly weapon, to wit, a wooden stick and or other unknown object, by striking the said Jonathan Black with said wooden stick and or other unknown object, and or through other unknown means. And then it lays out the mental state. It has to be deliberate, premeditated, or of all things committed during the perpetration or attempted perpetration of a robbery. The following instructions in this packet lay out, after you've assumed that Devin has killed somebody, her mental states. Instructions 6 through 16 talk about all the different mental states required. That's after you've determined that this person did the killing. There's even a number of instructions concerning robbery. It's instructions 17 through 20. You see, in the state of Nevada, we have what's called this felony murder rule. It's a shortcut. It's maybe basically getting to the shortest distance between 2 points to convict her of first-degree murder. There are, however, other instructions that I would like to spend a little more time on. And again, you are the sole judges of facts. You will review these instructions. But unlike us, who've had this case for some time, this case is new. You were introduced to this case when we all met and began talking at the beginning of last week. There is an instruction concerning expert testimony, instruction 33. Please look at that. There is a common sense instruction. And I'm going to flip to that. It's kind of telling. Both parties generally point to this idea of common sense. Again, shows the wisdom. Instruction number 34. Although you are to consider only the evidence in the case of reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in light of common experience, keeping in mind that such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. As I go through my comments, and trust me, I'm going to leave things out. It's inherent in the process. Please use your common sense. You've taken good notes and you've paid attention. Please review the exhibits and don't take my word or that of the state of Nevada. Reach your own conclusions. Review the evidence. There is an instruction that I think is of paramount importance in this case is instruction 32. It concerns the credibility or the believability of a witness should be determined by his manner upon the stand, his relationships to parties, his fears, motives, interests, or feelings, his opportunity to observe the matter to which he testified, the reasonableness of his statements, and the strength or weaknesses of his recollections. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. I read this instruction to you with Deviere in mind. You know, we started this case talking about motivations. Motivations dictate actions. Deviere is not on trial. You know, this case is not going to be, well, did we prove our case against Deviere better than they proved their case against Devin? Devin is the only person that's on trial. We have gone through the evidence in good faith, and I'm going to discuss that a little bit with you today in my summation, that there is evidence to believe that Deviere committed this crime. But you don't have to believe that to acquit my client. But I would submit to you that you should take that into consideration. The ultimate determination that you will make is the sole judgment of the facts, whether the state has proven this case beyond a reasonable doubt. Through the course of this case, and as you know, when we talked about it, we wouldn't have to ask a single question, present a single line of testimony. State fails to prove their case, she's entitled to a verdict of not guilty. But as this evidence has unfolded, I would urge you to see that perhaps the detectives in this case, the Henderson Police Department, were basically trying to choose the shortest distance between 2 points. I mean, hey, we knew, and we all know, and we're not making issue that she was with him on the night in question. It's easy to reach a judgment like they did. She's guilty. But you, as jurors, must consider all of the evidence. Because unlike when you read in the paper, so-and-so's caught, and you think, yeah, he's guilty, she's guilty, you determine whether a person is guilty, not the police and not the state of Nevada. I would urge you to read the reasonable doubt instruction. A defendant is presumed innocent until the contrary is proved. This presumption places upon the state the burden of proving beyond a reasonable doubt every element of the crime charged, and that the defendant is the person who committed the offense. And again, this is why we have addressed what the evidence reasonably shows concerning Deviere. A reasonable doubt is one based on reason. It is not mere possible doubt, but is such a doubt as would govern or control a person in more weighty affairs of life. And what more weighty affair of life do you have than to sit on this jury on this type of charge? If the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, she is entitled to a verdict of not guilty. Since this is a charge of murder, I'd like to begin my comments, and I won't be long. I mean, we've been here a long time, but this is important. Let's begin at the autopsy. We had Dr. Sims. He was the lead coroner here in Clark County for 19 and a half years. You heard his testimony. It wasn't much of a cross because he didn't say much to be disagreed with. We did, however, hear from Dr. Yagi. Do you recall the question that was posed to her? Would you agree with me that a decapitation is difficult to effectuate? Remember her answer? I don't know, I've never done one. We heard from Dr. Sims that yes, it would be difficult. It takes a lot. It's involved. Dr. Yagi missed the tattoos. It was in the report. We had Oriental John. That kind of goes to the weight that you should give her testimony and the thoroughness of her examination of the body. The state's relying upon Dr. Yagi's statement, her testimony that there was no injury on the hand. You got to consider the source. Dr. Sims testified that the cause of death cannot be determined without evidence of injury, and he was talking about standard practices. Obviously, these are very suspicious circumstances. In fact, if John was murdered, it's very reasonable to assume, common sense would dictate, that the person that killed him decapitated him. And through the course of this evidence, they have not shown a scintilla of evidence that she was involved in the decapitation. She didn't do it. Determination of homicidal violence cannot be used when in large part that fatty liver or drugs and alcohol are present. He was talking basically about industry standards. what experts in this field collectively agreed upon. And we saw a variation in this case from Dr. Yagi. In this case, we did have a combination of all three. You heard the testimony, about 20 times the level of THC, alcohol in the body. 0.02 was the alcohol in the blood, but Dr. Sims testified that that, in conjunction with this high level of THC, would cause a person to be intoxicated. That's important in this case because you will hear testimony concerning her concern, Devin's concern about not letting him drive. As you recall, we went through all those texts beginning back in 2018 concerning Yoko's concern. And again, I don't want to speak ill of the dead, and there was no showing of disrespect towards her, but it was an ongoing concern that she had. She didn't want her son driving drunk, and that concern was shared by Devin. She had his key. She took the key to the house. That's not evidence that she had a murder. This is extremely important, and there's been a great deal of issue made concerning this video evidence. As you recall, through the course of Devier's testimony, I read it to you at the beginning of the trial and read it to him, where basically we had a detective, it was the 12th of September, telling him, you're under the radar. We're here to clear you. I mean, when you look at the radar, when you look at this net that was cast, it has so many holes in it. The state would have you believe that both homes were under 24-hour surveillance. It's just not true. The evidence of Detective Lippisch and the other detectives show that. The state expects you to accept representations made by Detective Lippisch regarding the true time of the videos from this residence. And I want to start there. This concerns the state's timeline, which I would tell you flies in the face of common sense. But it's important to take into account how this evidence was gathered. If you recall the list of times or the videos that were shown, he supposedly didn't, it was on a neighbor's cell phone. We saw no logs. We saw no indication of the veracity or the accuracy of those times. The state's basing this idea that she's pulling up in front of the Pelagura residence and is somehow moving her car at 11:04 to avoid detection. You have to take this detective at his word. And again, I'm not necessarily saying he's lying, but he did a sloppy job of collecting that evidence. And this is the video evidence that I'm referring to. Remember, there was no embedded data here. We don't have time. He would have you believe that the vehicle is moved at 11:04. We don't know what time this is occurring. We do know that the vehicle perhaps was moved from the Burla, but we don't know the sequence of events. As you recall, and you will have the evidence, there was various blue lines showing triangles, and we heard that through the positioning of the GPS, you have movement, even if a vehicle is in one place. We don't have specific times, and we really don't know the order of how things occurred. We would urge you to believe and to consider that common sense would dictate that this was when Devin left the residence at 2:04. There's going to be a close-up here. You'll have a computer screen. Zoom in on it. Here you see the interior of the vehicle. You see Devin getting in. You see a bag on the passenger seat. And she leaves. Please pay close attention. And again, not that I'm trying to tell you to do it. We've had this case for a much longer time than you have. Look at the video evidence from 6505 Taylor Creek. Detective Lippisch testified several times that he could only speak to items that he canvassed for, but he was happy to testify concerning other detectives who went unnamed that collected this evidence. It's clear from the testimony of a forensic examiner, O'Brien, whose credentials and whose testimony went unchallenged that we presented to you today. He testified that one of the three videos was compiled from a series of screenshots, which the Ring camera is set to capture by default in the absence of video activity. Where are the other screenshots? They only gave us 3. I'm not gonna stand here and point the finger and say that this was done in bad faith. It was done out of sloppiness. Why weren't subpoenas issued? Why don't we get the complete record? This woman is on trial for murder. We heard nothing concerning them going to the third-party providers, Ring, Google, other parties. No, they're relying upon the cooperation of neighbors who are living their own lives and who very well may be indifferent to the gravity of this situation. Didn't give us the full picture. And that was the video that had constant, I mean, if you got a good scene into or a good view of the residence, it's incomplete. We just have these 3. And again, this is at the new residence where it's been referred to. Porcupine here, we've got a truck. You know, that there's been an argument made that Devier had to have been in the home the whole time. Based on what? Because the entrance to the neighborhood with the continuous camera doesn't show a vehicle. There's other ways to leave that residence. There's a walkway next to one house away. There's over the fence. This is something that's been discarded by the state. But again, I would submit to you that it goes to what Devin is thinking. It goes to her innocence. She starts trying to contact Jonathan on the morning of the 7th, starting about 4 a.m. She'd left him. She'd left him at the residence. The plan was they were going to take the girls to school that morning, and we have evidence, and you've heard uncontradicted evidence. That's what she did. The message she leaves him is concerning the girls' school supplies. She's letting him know that their daughter was sick, because we know that she's at that pharmacy, and it's a 24-hour pharmacy at 2:28 a.m. That's what went on. She hadn't killed him and decapitated him. She was worried about getting her daughters to school that morning. She sends messages concerned when he doesn't respond. The state claims, and again, this is where common sense comes into question. The state claims that Devin was answering Jonathan's phone from the house the morning of 8/7/2023. You heard the argument concerning the notifications. We did hear from Detective Skinner that they didn't put it on airplane mode. Those notifications wouldn't have shown up. That evidence, like so many other pieces of evidence, were mishandled. But the state's going to have you believe that she purposely took the phone from Paladera to Porcupine Rim and leave it out on the driveway, and at the same time be calling it and answering it and leaving it on the driveway. That flies in the face of common sense. She took it and left it there, and then is answering it and calling it to provide some sort of an alibi. She's lucky that in this very slipshod investigation that she has as much evidence that she does to present to you that she didn't commit this crime. Crime scene, footprints. There are footprints in the backyard. And we have, and I'll show you the photos, we marked them and had them admitted. We have this, the Henderson Police Department documenting these footprints, but then trying to basically throw shade on that, saying, well, they could have been there for some time. They weren't important. When you look at the photo, you can see that they're fresh. They wanted to argue that they're male or female. They didn't do any follow-up. There was no footprint comparisons to anybody's shoes in this case, much less Devier's. You recall Yoko's testimony, there were 4 dogs in the backyard. If that footprint had been there for very long, common sense would dictate that the dogs would have walked through it. They would have been sullied. They weren't. They were fresh. Again, they were not analyzed or tested. And there it is. And Detective Ozawa just kind of discounted that and said, well, we don't know how long they were there, but apparently no one really looked at Yoko's testimony and Yoko's statements. 4 dogs were out there for most of the night. This was a big point of contention. And again, these aren't red herrings. These go right to the very heart of the case. There was no blood cast off in the bedroom. In spite of evidence, uncontroverted evidence, the mechanical powered saw was being used to decapitate Jonathan. You recall, Coroner Yagi went so far as to try and compare a beheading by a mechanical tool there at a crime scene, and Dr. Sims took issue with this. She tried to compare that. These crime scene analysts tried to compare that to the dismemberment of a body under controlled conditions by specialized tools in the morgue, bodies that have been refrigerated. But nonetheless, she testified that they still wear protective goggles and aprons to protect themselves from this cast-off. Luminol, we heard no testimony whatsoever that luminol was used by the crime scene analysts. That would show indications of blood or attempts to wipe it out. Nothing. what's clear, and it was kind of laborious at the beginning of this trial, was Yoko's testimony, because her testimony was so crucial to the timing of this case. There were some difficulties with the interpreter. However, I submit to you, she speaks pretty good English. It was important to memorialize what she told officers the morning of in the 40-minute conversation, as well as what she testified to the grand jury. She testified that she saw Devin at 1 a.m. and Devin didn't have any blood on her. If you follow the state's timeline, it's sometime around then, and it's unclear, she's involved in this murder and decapitation. She stated that no gloves were worn by Devin when she met her at 1 a.m. And you recall the testimony concerning the dishes and the alcohol bottles. And there were some issues concerning Jonathan's level of drinking. 15 minutes. She testified that the light was on. That brings to question the veracity and the reliability of the statements through her multiple interviews that Devin made to the detectives. There is no blood visible on Devin's shirt at the CVS drive-thru pharmacy. Thank God that she stopped there, because again, we have real time. We have real evidence that shows that she didn't commit this crime, and not some detective's opinion. There's another issue concerning this, the mixture of ammonia, bleach, the stench. Remember that? We heard that the first responders, that they said that the smell got worse the longer they were there. If we're to believe the state's timeline, this is smoking for 9 hours. That flies in the face of common sense. Ammonia evaporates quickly. And again, your common experiences. The state never, and one of you posed a question to Dr. Sims. Again, it's the state and the state alone that bears this burden. Where was the expert to talk about that? That was important. This case was out of the ordinary. It's clearly gruesome, but because it's gruesome, it doesn't make that woman guilty. It isn't evidence that she committed this crime. Here we are, 2:27 in the 24-hour pharmacy, and you'll have this. Look at her. She's sipping her water. Apparently this is after she's murdered a man and decapitated him. She's reaching out of the vehicle. No marks, no blood, nothing. And Sims testified that this would have been messy. So she's just decapitated. She's murdered and decapitated Jonathan, and she's making sure that she picks up her daughter's medications on her way home. There was a very good question that was asked concerning, was there any stops? There wasn't. There were no, her vehicle didn't go to any isolated areas, to any trash bins. There's been times when I've gone through moves and I've gone behind the bonds and dumped trash out in their dumpsters. There's no evidence of that because it didn't happen. The state will have you believe that there's this bucket of blood that's the reciprocal of all this blood that's squirting out when she's sawing his head off. What did she do with that? If she did, the car didn't go anywhere. She went home. There's no rags. There's nothing in that vehicle. We do know that they recovered, and this is based in part of the video that we saw from the terrible herbs. Again, I don't want to point fingers, but her life is on the line. They didn't do their job. There was no direction of what to get and when to get it. We heard from Detective Lippisch that he got that video evidencing her clothes around the 11th of August. That warrant was served on the 7th. We didn't hear much about what they picked up on the 15th. They made a big deal about the shoes, the swoosh, but we showed you evidence in the photographs, and it's in evidence of the black shoes with the white soles. And she gets arrested on the 15th. Game over. It's done. According to Yoko, and this is important, and I read the statement to her because it was so dispositive. She said Jonathan's room was a mess. And there was this kind of a feigning of not understanding, and I said, man, these are your own words. And I read her own words to her. During her initial interview, she stated that there were 2 chairs flipped upside down. That's evidence of a struggle. But then we don't see that on the body cam. What happened? We don't have that in any diagrams of the crime scene. But when she spoke to police and thank goodness it was recorded, she talked about 2 chairs being flipped upside down. And obviously her memory would have been far better at that time than it would be now. But again, there were some questions by the state, you were traumatized, things were terrible. I'm sure it was. But the veracity of the statements and the accuracy of the statements shine through. She was trying to help law enforcement and give them clues concerning who committed this murder. There's no reference made in Devin's statements about chairs, about a struggle. Jonathan was killed after she left. What's kind of weird is that there were 2 belts tied together on the ground near the bed. There's been no explanation by the state, and we can't give you one, but something's going on in here. Crime scene GPS. Devin's car is trackable. We know that she didn't stop. She was there that night, and that's why she was charged. Her phone is trackable, clearly. No deviation is made to some remote location. She went to the pharmacy and went home. There's no anomalous stops, and this was brought up by you. She gets the medication and gets home because the girls have school early the next morning. The timing, and this is obviously where timing is very, very important. We do know when they leave the terrible herbs. You see 22:11. We know that when they got home, they spoke to Yoko. We don't know how long they spoke. But do you recall Yoko's testimony? Her words were, it was a very good day. She'd known for months that they were getting together. They were trying to unite the family. And you know what? No union is perfect. Hey, we all know that. There are ups and downs, but she and Jonathan had a union. The state in their first closing, they're going to get a second one, try and paint her as this devious, manipulative, conniving temptress. But think about that, the flip side, a 19-year-old. When we talk about motive, what drives a person to murder, is it not passion of a young man? His first love that's coming to an end when dad's coming in and moving him, the dad that he said was never there for him. It's kind of an archetype, the father that's killed by his son. I mean, it's in, I believe it's Isaiah 38:18. We've got these Greek stories of it, Oedipus. I mean, there's various variations of that, but it's an archetype. Saturn. It's known, and it's as old as the human condition. Fathers are sometimes killed by their sons, and that's why we wanted to underscore, and we spent a great deal of time in our opening statement, because we didn't know where it was going to go with Devier, but we knew that they'd had a relationship that had been kept clandestine. Devier covered for Devier, and Devin covered for Devier. This is important. I would submit to you that this is a more accurate and a more reasonable timeline. Yoko was awake. 10:58, there's a 44-second call to Devier from her phone. You recall, we get the text, and you want to talk about an alibi-type text, putting the girls to sleep. It's 10:36, I'm going to bed. That has been refuted by facts. He testified here that, well, maybe he woke up at 2. That was the first time. Previously, he had testified before a grand jury that he got home, put the girls to bed, went to sleep, woke up, Devin was there. That is a lie. Why would he lie? What motivation would he have to lie? He's a fairly smart young man. I mean, he was kind of catatonic here, and understandably so in the witness chair. But again, we need to look at motivations, because motivations, they author actions. At any rate, we knew the night before that Devin had been there late with Jonathan. But after we were relieved that he's asleep at 10:36, we got a 44-second call from Devin's phone to Devier. 8 minutes pass. 11:05, we get that 10-second burla in the Nissan Armada. That may have been moved. You're to determine that, because I tell you, we really don't know. The evidence is not reliable. Whether it pulled up and stopped, or what we saw there was Devin leaving, we don't know. States to provide that to you, the timeline. They haven't done that due to this slipping through the cracks in the slipshod investigative work. Now, an hour and 55 minutes pass. Yoko is awake. There's no suspicious noises or activities. And we have a 15-minute timeline. Because you recall, Yoko's into time. She corrected me. She looks at the clock. They talked for 15 minutes. And it was kind of like pulling deep. She admitted about the dishes and the alcohol. They talked for 15 minutes. We're to believe that, and again, this goes to Devin's statement and reliability after she's subjected to interview after interview. Yoko says the lights are on. The state would have you believe apparently that Jonathan's dead. She struck him in the head and he's dead. Meanwhile, she has this 15-minute communication. Again, no blood, gloves, chemical smell, any of that on Devin. At 1:15, Yoko goes back upstairs. And you recall yesterday, that was kind of rebutted Lana's testimony. They kept hitting her with that hour and 4 minutes. That's why you don't talk to the police. That's why you have a right to remain silent. One thing that we have learned is don't talk to cops, especially if you're the target, because they're going to take what you say and they're going to twist it. Yoko was equivocal in her testimony when she testified before us. This time, and she's just testified once before a grand jury, she's equivocal. She was awake the whole time. She looked at YouTube. She went to sleep. It's equivocal. But at 2 a.m., for the first time here, she says she hears the bang. I think we had the prosecutor bang his hand. She never talked about that before. But still, may have happened. 2:04, Devin's leaving. Maybe it was the door closing. We don't know. That's her testimony. You have to evaluate her testimony. But again, this is really kind of shedding light on this timeline. She previously testified that she heard dogs at 3 a.m. She brought it up 3 times during her police interview. Apparently, she felt it was noteworthy, and she testified to that September 14th before the grand jury. Yeah, the dogs are barking. It's 3 a.m. Someone's put the dogs outside. The facts, taken as a whole, and not this little piece here and this little piece there, show that this murder, and it's silly to say a murder didn't occur. Obviously, it did. It happened after Devin left. The facts, taken as a whole, bear that out. Again, you heard, and it's uncontroverted. Devin leaves at 2:04. What's of note is that presumably Yoko went to sleep after she went upstairs. Part of her testimony previously is that she was awake during this whole time. Where's the testimony of a mechanical Howard saw? It happened. It's more reasonable to believe that happened after 3 a.m. We don't know when it happened. She didn't do it. The dogs were outside barking. Somebody's in that house. Somebody has killed Jonathan and somebody is cutting his head off. Again, what kind of passion does that take? Not an on-again, off-again relationship that Devin had with him. It's a person that's enraged. Well, watch the TV, the police stories. They talk about stabbings are personal versus a shooting. What's it going to take to cut a head off? And what kind of anger and what kind of resentment is that going to cause for someone to do that? There's been a great deal of argument made and points attempted to be scored that Devin did that because she'd do anything to get her kids. It was uncontroverted that regardless of what was going on with the family workers, she had those girls from May 27th on. She had them all summer. And when we talk about motivations, we know that Jonathan was moving in. There was talk of marriage. And, they want you to believe that the rings weren't there. Look at this investigation. Look at the photographs of the trash cans. I believe one was at Exhibit 68. We have no evidence and nothing to show that they emptied that. And why would they take a picture or preserve a ring? They didn't preserve anything else in those trash cans. It's easy for them to come in years later and say, I didn't see a ring. There was no locations, and they'd go through hundreds of crime scenes. When they were there, when Miss Wilson was there, they were looking for weapons. They were looking for evidence of a murder. They weren't looking for rings, and they're asking you to convict her on this shoddy police work and have you believe that Devin's lying about these rings when there is no indication that they were looking for rings. This is the state's only evidence that she committed this murder and this decapitation, because you got to put them together. Common sense would dictate whoever did one did the other. The interviews of Devin Michaels. I'm going to focus on the third interview.
And then have you guys ever had a sexual relationship?
Yeah,
Okay.
we had.
Okay. But it's not there now?
No, I haven't had sex now.
This is important. This isn't something that Devin is making up. You have her medical records. The time, 12/5/22, vaginal hysterectomy. She's had surgery. She's not having sex. She's telling the detectives the truth.
Okay, we got that. Is there any reason why John's blood or anything DNA related would be in your vehicle? Because that got to go back to our station, our CSA, they're gonna thoroughly look for everything in that vehicle.
I couldn't tell you if he was bleeding from when he was doing the thing, he helped load up the truck, so if he was bleeding, it might be
Or your
my Armada. Like, he was putting the things in the car, like anything that he had.
there's gonna be obvious areas where blood doesn't belong if you're loading. So I'm just asking you directly, because if we do find any DNA evidence in that vehicle, obviously we wanna make sure we asked you if there would be a reason.
No, the only thing I knew he said was his hand that he hit on the table. That's the only time he ever said he was bleeding, and he said it got a pretty good gash.
That you didn't see that.
No, I did not, so I can't really speak on it. But he was still loading everything up, so I don't think it was really bothering him that much.
This is the inside of the Armada. For the testimony from Ozawa, it appeared the vehicle had just been washed. That's been disproven. The borough showed that that didn't happen. The location coordinates showed that that didn't happen. Look at the inside of this vehicle. I know my partner, Mr. Horvath, had asked Detective Spangler, well, was it very clean inside? I think he made a reference to teenage kids, something along those lines. This isn't well kept. I've seen much worse, but it's not well kept. The important point is we're to believe that there's buckets of blood in here. There's bloody rags. There's a head, a murder weapon, a saw. There's nothing in there. They sealed this vehicle and they took it off. If you're to believe that she murdered and decapitated Jonathan, you're to believe, common sense would dictate that there's going to be some indicia of a crime in here. Taking buckets of blood because they weren't at that residence. This made reference, and again, nobody understood the significance at the time. Miss Miriam did this. There's the table she talked about. It was a moving day. Injuries do happen. We're to believe, again, Dr. Yagi's, the reliability of her testimony. She said there was no bleeding injury. Well, we've got an injury right there. Whether it's bleeding or not, we don't know. But that's sign of an injury. And remember, this is the same doctor, the same coroner that said John didn't have tattoos on his arms. Big point was made about the telephone. And we're to believe that Devin is so sophisticated and so cool and so cunning and so informed that she can murder this guy, decapitate him, not leave any evidence, and then drop his phone in the driveway. More reasonable explanation is tired. She's got girls that are going to school in the morning. She's been carrying things. It's late. She obviously brought the phone. Whether it was knowing or not, we don't know. It appeared that it had fallen on the side. She tries to give an explanation. You recall about the cigarette butts? She didn't know the phone was there. That's why she was calling the phone, following up with Jonathan. She knew he wasn't dead because she didn't kill him. Another thing, there was a big point of contention. Sometimes little things can have very large implications. Remember the issue about the blood on the screen? Papakostas, the DNA expert, testified that she couldn't confirm that it was blood. There's a presumptive test, but the confirmatory test, and some of you are far more knowledgeable than I am, it was not. She couldn't confirm that it was blood. So then the state recalls crime scene analyst Miriam to apparently discredit their DNA expert in reference to the blood. And this is the entity that's charged with proving this case beyond a reasonable doubt. They're calling a crime scene analyst on the presumptive test to discredit the DNA expert who gave testimony, uncontroverted testimony, concerning the lack of a confirmation for this blood. We know that John's DNA is on the phone. I would submit that it is somewhat significant in determining whether the state's proven this case. Devin's isn't. It was handled. Maybe there weren't epithelial cells left from Devin. Clearly, Devin took the phone, knowing or not, and I would submit to you that given the circumstances and the chaos of a move, she didn't know she had the phone. It's not evidence that she killed him. Just like the key, it's not evidence that she killed him or the wallet. She's going to go through all this work to leave this, this crime scene spotless or clean and not leave anything behind, no blood, nothing in her car. And she's going to drop the phone and then make calls to it. This is what the state is relying upon, this interview. And you recall the tenor of this interview, please don't just look at one part or another. Listen to the whole thing. The power dynamic. You've got two large men. You've got a woman who they had said, we Mirandized you earlier today. You have to ask yourself what went on. What happened before this interview?
John?
Susan Jonathan, when that's on?
Yeah, and he had his boxers on.
They had his options on.
I don't know, he had his boxers on. His boxers were black boxer briefs. He had boxer briefs on.
That's what I'm talking about, what she did, but keep looking at that. Take another look at this.
This was into the interview, and it's a fairly lengthy interview. She'd had multiple interviews before. We heard in this interview that they had told her previously that day about the decapitation. So there's more going on. She knew. You know, it's at 16:01, and it's interesting that the state showed you the exhibit, the one that she supposedly wrote. When you look at the original exhibit, it says handwritten by Devin Michaels. It wasn't. She drew a line, and that's significant. It was Detective Christopher that wrote that. And again, this is in the crises, in the crucible of a very confrontational interview. She didn't author that. And I'm assuming that Mr. Giordani is going to stand up when I sit down because he gets the last word. He's going to say that somehow, how could she have known that? She hadn't been shown the photos. This gentleman had seen the photos and he filled in those details. And she's sitting there having been arrested previous to this interview and facing the horror of being accused of a crime, a murder that she didn't commit. Here's the boxers. Why lie? Why lie? When she left, he was wearing those boxer shorts. She was consistent in that. Why choose that hill to die on? She was telling the truth.
Have you had moments in the past where you
Yes.
have been, stuff where
Yes,
is that?
there's things in my past where I cannot remember. And yes, I have talked to my doctor about it. Yes, they're trying to figure out what's going on with me. Yes.
Okay, you don't have to tell me if you don't want to, but what is wrong with you that you say that?
I don't know, they're testing me now. I went yesterday, for whatever reason, my brain tingled and then I blacked out. And I literally have it on documentation from the doctor and they're trying to figure out what's going on with me.
This interview was on August 15th of 2023. This condition that she's talking about, it's documented 6/7/2023. New patient established her patient she feels like tingling, vibrating in the back of the head, comes and goes, denies headache, has dizziness. This isn't some ploy. I mean, she's in this high pressure, confrontational interview, and she's trying to give as truthful information as possible. She's had some problems. This isn't some defense where, oh, she blacked out and didn't know what she did. She didn't commit this crime. She didn't commit this decapitation. She's had some issues that she's been trying to address. And again, she's being truthful to these detectives. It's confirmed.
Absolutely. You're you have the audacity to get info. Shame on you. That's terrible.
Get out of here, I'm not this.
Oh, so there's
I didn't do it.
there's an anger now,
I told you from the beginning I didn't do
huh?
it.
How do you feel against him?
No! There's not, I could have done too.
She's pushing back. She's been interviewed over and over again. She's telling him, I've told you I haven't done this. What we're dealing with now is a woman that's denying that she committed this murder. You know, it'll be up for you to determine whether she hit him in the head when he was grabbing her leg. She was consistent that he was alive. He was breathing. There's no evidence that she hit him in the head. And again, given this, we know that when people are confronted, they'll try and give something to appease the other party, this power dynamic. She was trying to give. In this interview, we'll read, they threaten. I mean, what you do here is going to determine what happens with you and your daughters. She gives a little, but then snaps back and says, I didn't do this. And she's expecting, through all these interviews, for them to pick this up and do their job. But they'd already made their minds up. You heard from Lanai yesterday. In their minds, she was guilty. That's it. And we're dealing with this investigation that you heard from Sean O'Brien, 3%. We're dealing with 3% of the information that was available on those devices. But still, in that 3%, we've been piecing together what really happened. We do know, and it's clear, incomplete Celebrite reader files. Critical database files are missing from the phones. Now, years later, we're trying to piece together a defense to defend a woman that didn't commit this murder. There's artifacts which would indicate the need for further investigation. And Sean O'Brien testified that generally, as he's been a forensic analyst, he's been involved in law enforcement. There's supposed to be this back and forth. Hey, get us this. As this investigation develops, we need more information. There was no indication that that occurred in this case. She's at the house. She's the low-hanging fruit. She's guilty. The end. All investigation stops. Image of Devin and Deviere. And again, we'd like to have more, but we can show you this image. Now, all the images that are available on a cell phone, I think I probably have 4,000. It's going to be the state's position. Well, this is just randomly popping up. Devin had said that he was asleep, or Deviere had said that he was asleep at this time. He testified under oath. He lied under oath. Look, there's a Discord chat application, 231. This is telling. The state can play 3 phone calls from the girls who are adorable. Those were all after 11 o'clock. We have no proof where Deviere is. But we have 2 indications of 2 artifacts at 2:12 a.m. and 2:31 a.m. that he's up and he is engaged. There's a deliberately deleted file. This is the image, 2:12:38 a.m. This is after there's been 3 calls from the home phone that night to Devin. 3 of them were the girls. What about the other 8? But of all images, at 2:12:38 a.m., this is being looked at on Deviere's phone. Gamebox. Again, and this is important, this was not preserved, this was overlooked. There's photos, he was a gamer, they had issues. Gamers are on their game platforms and they talk to other people. We have a Discord file, there's a remnant of that. He's using that at 2:31 a.m. in the morning. He's up. He didn't drive his car over there, and again, I can't tell you for certain if he committed this murder, but he could have easily gotten out of the house, and he's not going to walk. He's going to talk to a fellow gamer. We now know that he's up, and he's lied. He's lied under oath. What does he have to lose? I mean, he was able to avoid the motives through the course of this investigation concerning getting kicked out of his house and losing his wife, who he, based upon all the photos, and we didn't have to go through those, you saw them, he was in love with her. But we do, in this 3% that's available to us, we can show you that he was up. Not 1 indication, but 2. And given the nature of that photograph, the multiple phone calls that were made earlier, and now we have this Discord, we have a remnant that he's on and at. It's not too hard to imagine that he went there. Those are the facts. And the timelines. You call the detectives that for the Henderson Police Department that testified, they set out timelines, but they didn't do a more in-depth analysis. And this is what our analysis, only 3% we were able to show he was awake. This was deleted. It's there. I'm not saying that was that night, but that's something that should be taken into account. Headed there now. He's there in this area, and you'll have the exhibit. He's next to a remote area. Don't know if he had a job there or not. This is the morning after 8/7/10/25. When detectives interviewed him, he'd said, hey, I've been drinking. We don't know if he'd been drinking all night. We don't. He's a drinker. He's in a remote area where, and obviously there's been no testimony, there's been no investigation in those wash areas. We know he was over there. We know he was up. We know that he was looking at a picture of him and Devin. You see on the crime TV shows about motive, means, and opportunity. He had all 3. He had the motive. He had the means. He didn't walk there, but he was talking to somebody. Clearly, he had the opportunity given the timeline. But again, I'm not going to stand before you and say he did it. We don't know. She didn't. These were texts that were between him and his father. You have nothing to tell me, WTH or TF. I thought you were my seed. What I can know, I can't fuck with you. Where that's true, devil shit. It was clear, and he tried to smooth things over through the course of his testimony, but Deviere did not like his dad. he had an affair with his dad's girlfriend. You know, these things don't reflect too good on her, okay? They reflect poorly on Devin. But Devin's not here for good moral character. You can despise the choices that she made, but you can't convict her for murder that she didn't commit. This is their home. The home that he's being kicked out of again. There's the walkway down the side. There's a way to get out the back. There's no cameras that were pulled on Rebecca. We don't know. The police did a slipshod investigation. We can't show you him walking away. They didn't collect the evidence, but the motive would point to Debbie Eyre. This gun, there was an issue made concerning that. That gun was looked at the afternoon of, I'm sorry, that's another gun. There's guns in his possession. We don't know if that person was shot or not. Jonathan was. The swords, again, we're not trying to throw these things out, aha, but this just shows the conscious indifference on the part of law enforcement in collecting evidence that could exculpate her. Their minds were made up. She was guilty. There's so much evidence here that you can go through and look. Again, thank you for your patience. Thank you for your attentiveness. You know, this is the last chance that we'll have to speak. There's going to be things that I have overlooked, things that I missed. Don't hold them against her. Hold it against me. You remember the movie 12 Angry Men? The jury went through and exonerated that young man. I'm going to ask you to do that, to look at the facts. You may not be comfortable with the verdict of not guilty. She's done some bad things. She didn't commit this murder. She didn't kill him and cut his head off, because those two things are combined. Common sense would dictate that they are. She's not guilty of this charge. Thank you.
Second, are you prepared to give your rebuttal argument? Ladies and gentlemen, because the state has the burden of proof, they are allowed to open and close the closing argument.
Let's talk about reality now. I want to commend my colleagues over here who represented Ms. Michaels first, because they've done an exceptional job. And Ms. Michaels is entitled to a fair trial, like we talked about in jury selection. They've done a good job of coming through and poking as many holes as they can in the evidence, and I commend them on that. But make absolutely no mistake. That woman is guilty as sin. That family deserves justice. Those girls deserve justice. Do not take this lightly. Just because a real polished defense attorney gets up here and spins a yarn for you, do not take this lightly. Those people deserve justice. If I were to tell you that a defendant confessed to a crime, described how she did it, everything she said matches the crime scene, except for the part where she minimizes or potentially blacks out the aftermath, you would say, well, that's pretty damn obvious. And some of you were probably sitting there when we played that confession the other day, yesterday maybe it was, or the day before, and go, why didn't you guys play this 2 weeks ago? We could have kind of sped this process up. Maybe you're thinking that. Because we have to show you that the cops did their job and she is overwhelmingly guilty. We wouldn't be doing justice to that family right there if we just played that confession and walked. And we didn't. We put 2 weeks worth of evidence up here to show you Debbie Eyre sure didn't do it, and she did. There is no reasonable doubt in this case whatsoever. And I want to address kind of an elephant in the room. You know, Mr. Draskevich just got up here at the very end and he told you those two things, common sense dictates those two things go together. And I kind of agree with that, right? The person who killed him probably decapitated. But make no mistake, she's not on trial for decapitation. She's on trial for murder. She told you she did the murder. Now, she minimized it. She told the detectives that she hit him over the head and he was still breathing. Of course she did. But she admitted to the act that caused his death. Are we really, as reasonable men and women, going to believe this was a fatty liver or a marijuana overdose? Are you kidding me? That guy was murdered, and then his head was chopped off. And here's the elephant in the room. I don't care if you, for some reason, believe Debbie Eyre somehow snuck out of his home like a ninja, crossed town, and cleaned up the job. I don't care. She's not charged with decapitation. Look at the pleading document. She's charged with killing John. That is it. That is your job. Did she kill him or not? And the answer is absolutely yes. I need to show you a couple instructions because they're important. Bear with me. I know you're probably tired because we all are. But this is too important to just gloss over. This is the beyond reasonable doubt instruction. Mr. Draskovich addressed it. I want to tie this into another instruction. Doubt to be reasonable must be actual, not mere possibility or speculation. Instruction 31, direct versus circumstantial evidence. The top part is really important. I'm going to address that in a minute, but this one down here that's underlined is also important. You must not speculate to be true any insinuations suggested by a question asked the witness. So a question is not evidence and may be considered only as it supplies meaning to the answer. So everything Mr. Draskovich said through the course of this trial was a question, right? It was a question. That ain't evidence. So you tell me what piece of evidence, what single piece of evidence suggests Devier did this? Not one. Not a one. And when you start accusing an innocent guy of murder, Devier, you got to think about this for a second. That young man was taken advantage of. And like Miss Griffith said, it's not like he wasn't enjoying it and liking it and into it. No doubt. Mr. Draskovich in his opening statements suggested that Miss Michaels has a history in the adult film industry. Did you ever hear me ask that? No. Did you ever hear me or her mention that? No. Because Mr. Draskovich is right. She's not on trial for having a past. Doesn't matter. The only reason that does matter is because it dictates that relationship with Devier a little bit, colors it. She is an experienced woman, much older than Devier. He's a young knucklehead, and I would submit to you that when you heard from him, no disrespect, but that guy's not a criminal mastermind. He's not somebody who snuck out the back of the house, evaded all cameras, he had left his phone behind because he was thinking ahead to what he was going to do, somehow made it all the way across town, even though he didn't have his phone to contact anyone. There's no Uber notifications or pickups or anything suggested. There's no calls, no texts, nothing after 11 o'clock. So who did he contact and when? There's no evidence that Devier was involved in this. None. There's actually evidence to clearly refute it. You heard those voicemails, and we can agree those little girls they're precious, they're adorable. Those voicemails eliminate this alternative suspect, which I will refer to as a scapegoat, because that's what's happening to him. He's being scapegoated, and it's not right. Those little girls said on those voicemails what Devier was doing. He was knocked out, probably passed out, if we're being honest. And you didn't hear any other voicemails afterwards. You saw more calls from the landline. If Devier had got up and snuck out, because we know the one little girl is awake and panicking and like scared and where's mommy? She should have been home a long time ago. Where's mommy? Wouldn't there be another voicemail where they're calling going, Devier left us? Like, really, mom, where are you? Of course there would. Of course there would be. And there isn't. That's because Devier was home. And you know that because he texted and he said, I'm going to sleep. He's no criminal mastermind. His phone is at home. There's no evidence his vehicle's left. There is zero evidence that Devier is involved in any way. Zero. And so Mr. Draskovich brought up a good point with the instruction that Miss Michaels is the only one on trial. That's instruction number 36. I want you to think about this for a second before you let a guilty person walk. Okay, think about this. Imagine if I were to stand in front of a bunch of jurors and try to prove Devier's guilt. Imagine that. That's not what we're doing here. That's not what this is about, but imagine that for a second. Can you think of a single piece of evidence I could with a straight face present to a jury and say Devier did this? A single piece, other than speculation and really good questions by a really polished defense attorney? There is not a piece of evidence. I would be laughed out of the courtroom if I tried to prosecute Devier for this homicide because he didn't do it. He had no reason to do it. Go look at the text messages between him and his dad. We included a bunch of them. Did he worship the guy? No. Did he hate him? Who cares? He didn't kill him. There's no evidence to suggest it. He says throughout the text messages to his dad, hey, what's up? You'll see it. There's like years of it. There's 2 years of it. And then those texts that Mr. Draskovich just showed you with the devil shit, I would submit that's a reasonable thing when you learn that your son is having sex with your ex or is married to her. That's reasonable. But then, they left out a text that's right after that, where dad is reaching out to Devier like months later saying, hey, this wasn't some big, rift, homicidal relationship between dad and son. Now, when you're thinking about motive like that, you've got to think about this defendant. She told you in that interview with Detective Lina and Christopher why she did it. She said it clear as day. I didn't think he was really going to move in. the walls were closing in on her, and she made a real horrible decision, a real bad decision. She said that she very specifically got up. He was down on the bed getting a massage. Got up because she was a little pissed off, I think were her words. Maybe don't quote me on that, something like that. Walked across the room, grabbed this heavy blunt object, bashed him over the head, and he went limp. That's a confession to homicide. Okay. On top of that, she told a DFS worker, when you're thinking about motive, in the context of losing her children and homicide, specifically, which she brought up, she said she had to do it. She had to do it because that's how she felt. And I'm going to answer or try to answer a couple of unanswered questions for you. We all get this evidence before trial. You know, we're all obviously somewhat prepared. I'm not like tooting our horns, but we're prepared. We know the evidence when we come into this case. There were clearly going to be unanswered questions in this case, right? There's a missing head. There's a missing murder weapon. There's missing implements, no doubt. But think big picture, forest from the trees. Think about reality, right? Criminals ditch murder weapons all the time. Criminals try to cover up what they've done all the time. Just because she ditched the head and therefore the doctors can't confidently say what injury did it, does that mean she gets a reward? Like, does she get to benefit from the actions she took to cover up? Of course not. Does that mean we can't convict her of murder? Of course not. And that is why I asked Dr. Sims those questions earlier. I didn't challenge his credentials. Like I've dealt with him on cases before, as you probably noticed, and he's a smart enough guy. He's very educated, but he's not disputing that a blunt blow could kill a man, right? He is saying exactly what Dr. Yagi said, the decapitation is post-mortem. And you know what he didn't say, which should be very notable for you, that there were other bleeding injuries on the body, including the hand, right? Because there weren't. He didn't say that because there weren't any bleeding injuries to the body except for up here. And that's how we know she did. That droplet of blood, you can go back and forth about the DNA analyst not confirming it's blood. Well, DNA analysts actually look at DNA profiles. And DNA is in every single cell of your body, including your blood. And so, no, a DNA analyst is not going to come in here and say, John's blood was on the phone. She's going to say, John's DNA was on the phone because she's a DNA analyst. That's what that is. John's droplet of blood being on that phone convicts the defendant even without her confession. Set those, two confessions actually, because she told the DFS worker she had to do it. But set those aside for a minute. There are no bleeding injuries on his body except for up here. The phone left at 2:04 with a droplet of blood on it. That means the murder happened before 2:04. It had to. Nothing else would make sense. Nothing else would make sense. She, the defendant, traveled with that phone. Okay. So then you got this other big glaring unanswered question. Why, how could someone be capable of doing that? That question, I can't answer for you. Okay. This is reality. It happened. I would submit to you that there is a chance that what she said about that hour and 4 minutes is true. Maybe our psychology major could talk about this. But I would submit to you that she may have been genuinely telling those detectives the truth that she didn't remember chopping John's head off. Because this is beyond anyone's wildest dreams. Violent beyond all imagination. And there is a good chance she blocked it out. That doesn't mean that she walks out the door because she says she can't remember. It convicts her. There is no way she didn't do this. The evidence is absolutely overwhelming. And I need to address a few points because I just can't leave them unsaid, so please bear with me. Mr. Draskovich called into question Devier's testimony, and I want to bring this back for a minute. I think Devier is pretty well excluded, but he walked into this courtroom, and I want you to remember that I asked him the question, did we bring you back? We didn't have to arrest you or anything. He came back willingly. He flew here, right? He brought his girlfriend, a little more age appropriate now. I guess he's learned his lesson, but walked in the courtroom willingly with that big old camera and all you strange faces to him. And he sat on this witness stand. He swore an oath to tell the truth. He got up here. He testified. He looked at his wife. He looked at all of you, he looked at me, he looked at the marshal with the gun and the badge, and he testified to the best of his ability. Now, I am not and will not endorse his character. I don't know the guy. I've met him a couple times because he's a witness. But you got to see him tell you the most intimate details of his life. And I asked him straight up for a reason, and I did this early in the trial because we just learned he's the defense. Put him up early, and I asked him, did you kill your dad? And he said no. Now, I know he's a stranger to you, and you can't just accept his word, but you got to consider the circumstances and what it took for him to do that, to put himself in front of the world, and testify about all this. Willingly. He came back. We flew him back from California, and he came in here, and he answered questions from a very skilled defense attorney for however long he was on the stand. Think back to that. Did that kid strike you as someone who snuck out of his home, plotted this big old thing, and killed his dad and then somehow covered it up? Or did he strike you as someone who got himself in a bad spot, his words, tried to fill some shoes he had no business filling, and made a series of mistakes in relationships? His testimony from the stand has to be considered in context. And it's all corroborated. Now, I would submit to you that if he came up here and he said every word consistent, precise with everything he said over the last 2 years, then you might rightfully be a little suspicious. Like, oh, what is he studying for this? He had some inconsistencies. We don't shy away from that. He's not perfect. I asked him a question. I think the word I used was tumultuous, and he's like, what does that mean, sir? I don't know what that means. He's not a criminal mastermind. No disrespect to Debbie, but he's not a criminal mastermind. He's a scapegoat. Don't let that happen. Need to address our pleading document. Mr. Draskovich brought this up, so I just have to address it. So you heard in the beyond a reasonable doubt instruction, it says the state must prove every element of the offense beyond a reasonable doubt. This is a legal pleading in Nevada. We are permitted to use unknown means and manner of death and unknown deadly weapon. This goes back to what I was saying earlier and what Ms. Griffith said about the deadly weapon instruction, where it says the state is not required to recover the deadly weapon used and present it in trial. There's a reason for that, because like I said earlier, this happens all the time. We don't reward criminals who are smart enough to get rid of the weapon. In addition, we don't reward criminals who are smart enough to get rid of the head after they crushed it. That's why we are legally permitted to do this. Unknown object, unknown cause. Only question is it murder? Is it not? Did she do it? That's it. And it's absolutely first-degree murder. Mr. Draskovich brought up the robbery instruction, or the robbery pleading felony murder stuff. So I need to address that as well. Instruction 18. So when you first heard the charge read by the clerk, I'm sure you're like, what do you mean by robbery? This doesn't really, it doesn't really make sense. This doesn't really seem like a robbery, but bear with me a second. Taking property by means of force is a crime. The motive and reason behind it is separate. So yes, she took his wallet, his keys, and his social. We're not saying she took that for its value, right? It's not like the traditional robbery. The evidence says she took that for a reason, and it all comes down to one thing, and that's the girls. She took the Social Security card because she knew she had John out of the way, and she was going to make some changes and live the life that she wanted to live. So it is by law a robbery what she did. She killed someone, took their property, but we're not saying that she took the property to take the property. She took it because she wanted the girls and she wanted John out of the way. Instruction 29 is the motive instruction, or we call it the motive instruction. Motive is not an element of the offense or the crime charged. We're not ever required to prove motive, but you're permitted to use it to color kind of the facts of the case and determine whether there was a motive that could lead you to convicting on the crime. I've addressed motive a little bit. I just want to kind of wrap up that idea with this. John and Yoko and his side, they had a very different understanding of the moving situation than the defendant. She didn't want it to happen. Go look at the text, especially the ones that Ms. Griffith showed in her closing. John is continually saying, I miss my girls. I miss my girls. I want you girls back. We need to put this family back together for the sake of the girls. And go look at the defendant's responses. Those ones that Ms. Griffith showed. One was, I'm glad you appreciate what we had or how it was back then. And then that last text she put up where John is saying, we need to do this, we need to have them under the same roof. She doesn't respond. So go look at those when you're thinking about motive and tie it in with the last statement, the confession. There is no doubt that both sides have been aware of this potential for a move. What I would suggest to you, the evidence says, is that she didn't want John moving in, and John did. John wanted that. And it didn't become real until that night. And you know that because of the conversations with Devier. He's still there. He's literally still living there. So if he was going to be moving out for John to move in, why isn't he moved out already? That's because no one expected John to try to make the move that night. And that's when the walls started closing in on her. She's thinking in her head, I want my girls back. I want my girls. That's it. This guy can't move into my house. That's not what I want. She wanted him out of the way. And she did what most reasonable people wouldn't do. She made the decision to take a blunt object and bash him in the head and kill him. I want to address a few things with the defense expert. Mr. Draskovich showed a couple of cameras and a couple of texts or activity, 212 and 230. One's a Discord, one's a photograph. Remember what their own expert said. That wasn't active activity. That could have been background activity. It could have been active. He can't say that. So whether Devier woke up and activated his phone at 212 or 230, well, that just tells you he's still at home. And if it's just background activity, then who cares? Either way, it's not good for the defendant because it rules out Devier. It's either with his phone or it's a nothing burger. Mr. Draskovich talked about the boxer shorts being off, and I already mentioned this. The defendant may very well have blocked out what she did after she killed him. And whether she took the boxers off or not doesn't really matter. It's probably very likely that he was naked when they were having this massage situation, but the boxers being on scene have no real import in this case. Mr. Draskovich talked about the CVS pickup, and I got to address that. So he said, and he showed you the video, there's no blood on the defendant in that drive-thru. Now, we all watched it together. I don't see any blood from here up from what you can see. But do not forget, that shirt was never recovered. Neither were the shoes. Now, I'm not arguing to you or suggesting that I know what the defendant was wearing when she decapitated him. She could have been naked. She could have put John's shirt on. She could have changed her clothes, a number of things. But what I am telling you is that white shirt, from here up, maybe no blood on it, but it's never recovered. So we don't know if there's actual blood on it. Mr. Draskovich asked you a question, and I need to provide an answer. He said, is that a woman picking up this medication for her girls that's just done this, has the wherewithal to have just done this and go pick up medication? Yes. Yeah, that's reality. You heard the voicemails. The little girl was saying, you were going to get my medication. I'm not saying that the defendant is a bad mother. I will not say that. That ain't right. She took her children's father away. That's a bad thing she did. But did she care about her girls? Obviously. She stopped to get medication? Obviously. That doesn't exonerate her in any possible way. And neither does the post-homicide messages she sent to the victim's phone in the early morning hours. There's two very real explanations for those messages. Number one, you already know the extremes she went to cover up what she did to his head. She took it. That's extreme. She poured chemicals. She took a bunch of stuff from the scene, probably a towel too that was on top of him when she did the chopping. It's not outside the realm of possibility that she sent a text and made it look like she thought he was alive. That's certainly not unreasonable. The other explanation, as I've intimated to and pretty much said directly, is that she doesn't remember the real bad stuff. And legitimately, in her mind, he was still alive after she hit him. because from then on, she blocked it out. So take those text messages for what they are. They're either she's alibying herself or covering up, or she genuinely doesn't remember the wet work. That's what that is. I have to mention the timing of the big confession, not the one to the DFS person, but the big confession. If this is all, there's no evidence to say this, but according to Mr. Draskovich, this is the defendant covering up for Devier. If that is true, why does she confess after she's arrested? Right? She's already been arrested. Devier's gotten away with it. Why does she confess after? Unless it's what happened. Mr. Draskovich showed a couple of videos, the small movement off screen. Remember the 2696 video? He showed the small movement off screen, and I believe he said, I'm sure it was just misspeaking, but I want to make sure it's clear, that that was the 204 movement. That was not. That, according to the detective, that was the 11 PM movement when it goes off screen. And we know that for a fact because the Burla shows that exact movement at 11, or it's 11 or 1104, I can't remember. The 204 footage on that video is when you can't see the car, it's already out of frame, but you can see the lights turn on and it leaves. And then that is also consistent with the Burla, so just needed to clarify that. I want to briefly address the girls. So you didn't hear from them in this trial. You can probably imagine why we wouldn't want to put them through anything more than what they've been through. I would just ask you to, that's my decision. I live with that decision to not call them. But I would submit to you that you heard everything you needed to hear from the girls in those voicemails. Devier was home. Devier was asleep. That's it. Need to briefly address this DNA stuff. So Mr. Draskovich made a point about the swords, the shower earlier in the trial, not an argument, but no blood being in the Nissan Armada and the footprints. And I just want to take this to its logical conclusion. So say we swab the swords and any one of the three's DNA is on it. What question does that answer for you that hasn't already been answered? If Devier's DNA is on it, it's, well, he's handled the swords before. If the defendant's DNA is on the sword, it's, well, she lives in the home, of course her DNA is on the sword. If John's DNA is on the sword, it's, well, yeah, those are his swords and they were just moved from his house in the move, right? That doesn't answer an actual question in the case. DNA being in the shower. The defendant's been to the home many times. Have we found her DNA in the shower? What is that going to change for you? Absolutely nothing. No blood in the Nissan Armada. There is so much evidence of her covering up her acts at the crime scene. It should not be shocking to you that she could have wiped up some blood if there was any in the Nissan Armada. We know from the patterning at the scene, and you look at it for yourself, the blood on the ground, there is something she used to collect that head. There is a very straight, clear line on the border of that blood that suggests that something caught that head. And whatever that was, she took it with her. And when the defense says there's no stops along the way, we agree. But what they can't say, no one can say, is what she did when she got home. And you may remember that many times, different witnesses talked about it being trash day. It is not very hard to walk over 2 homes or 3 homes and dump a bag or basket or whatever it is in a trash can. And, I got to address the investigation. Now, the detectives are all learning this stuff as the investigation goes along. They didn't have the Burla and all that stuff when they go to Porcupine Rim on August 7th. Should they, because of they did know there was a head missing, should they have checked every trash can in the neighborhood? Yeah, probably. But they didn't. Okay. That doesn't mean that she didn't dump the head in the trash can. And that doesn't mean that this investigation gets the case thrown out or the defendant acquitted. These detectives actually did a pretty darn good job of follow-up investigation. When they suggested that she was the convenient, shortest distance between 2 lines, I disagree with that. Because remember, they found all that stuff in her home on August 7th. All that stuff, highly suspicious, blood on the phone. Did they arrest her then? No. Could they have? Yep. They didn't. They went and did mountains of follow-up investigation. All of that confirmed the suspicions. And then she confesses after she's arrested. It's too important to miss anything, so bear with me. I know it's getting late. Almost. Instruction number 35 is important. In arriving at a verdict in this case as to whether the defendant is guilty or not, the subject of penalty or punishment is not to be discussed or considered by you and should in no way influence your verdict. I want you to take that to heart. There's a phrase that's commonly thrown around in this courthouse that goes, admit what you can't deny, deny what you can't admit. I'll say it again. Admit what you can't deny, deny what you can't admit. I want you to think big picture, forest from the trees, just one more time. When there is a confession and DNA and mountains of phone evidence and video surveillance, what could the defense possibly do? She's covering up. The only thing that these very skilled defense attorneys could say in this case. We, luckily, have a mountain of evidence to disprove that. Admit what you can't deny, deny what you can't admit. They were painted into a corner. I commend them on their job, but what they did is they blamed an innocent person for a homicide he didn't commit. And I don't want you to blame the defendant, Ms. Michaels. I don't want you to judge her based on whatever her past. No one's asking you to do that. I also don't want you to take into account whether she's a good person or a bad person. She seems like she has some good qualities about her. Seems like she's trying to be a good mom. You must not make this decision based on sympathy or a popularity contest. Mr. Draskovich, very likable. We're not here to do a popularity contest. This is real stuff. Okay? Real stuff. Do not think about whether you think she deserves a little leniency or redemption or this is a one-off. She lost it. None of that matters for you. That matters for the judge, Judge Jones, who in her wisdom will sentence the defendant, not you. That is not your calculus. Your job is simple. Did the defendant do it or not? That's it. Please remember your oath to follow the law. It's my understanding the judge is going to let you stay a little bit after to deliberate tonight. I'm sure you might get instruction on that, but please don't take this lightly. This is important to more people than just the defendant. She is guilty beyond a reasonable doubt. Guilty of homicide. Thank you for your time and attention these 2 weeks. We really appreciate it.
Okay. I'm now going to ask the clerk to swear in the officers to take charge of the jury and the alternate jurors.
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself, unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into court when they have so agreed, so help you God.
All right, ladies and gentlemen of the jury, as you know, a criminal jury is composed of 12 members, and there are 14 of you who are here. That is because 2 of you will serve as our alternate jurors. This means you are not discharged from your service as a juror. Your service may still be needed if one of the other jurors is no longer able to participate in deliberations. In this case, our alternate jurors are juror number 13, Ms. Fitzpatrick. May the record reflect we are outside the presence of our jury. Do you guys have any further matters?
All rise for the jury.
No, wait, let's bring seat.
Please be seated, Your Honor. The jury's all present and accounted for.
We are back on the record in C 377239, State of Nevada versus Devin Michaels. The record reflects that Ms. Michaels is present with her attorneys. Deputy District Attorneys on behalf of the state, we both parties stipulate to the presence of our jury.
Yes, Your Honor.
All right, ladies and gentlemen of the jury, has the jury selected a fourth person? Okay. And Mr. Gilbert? Mr. Foreperson, has the jury reached the verdict?
Yes.
If you could pass the verdict form to the marshal. All right, the clerk will now read the verdict into the record.
District Court, Clark County, Nevada. State of Nevada plaintiff versus Devin Jade Michaels, AKA Devin Willett, AKA Nikki Fairchild, AKA Tracy Baker, AKA Tracy Nicole Tavares, defendant. Case number C-23-377-239-1, Department 10. Verdict. We, the jury, in the above entitled case, find the defendant, Devin Jade Michaels, as follows. Count 1, murder with use of a deadly weapon. Guilty of first-degree murder with use of a deadly weapon. Dated this 14th day of November, 2025, signed Aaron Gilded. Ladies and gentlemen of the jury, is this your verdict as read? So say you one, so say you all.
Yes.
Does either side desire to have the jury polled?
No, Your Honor.
All right. Ladies and gentlemen of the jury, I want to thank you very much for the time and attention that you paid to this matter. The right to a trial by jury is a right that's guaranteed in the Constitution, but it's a right that we cannot provide without our citizens like you being willing to sit and serve your civic duty as jurors. I do appreciate the time that you gave us tonight, so on behalf of the court and the parties, I want to thank you for the time and attention. I know that this was a lot that we asked you to do, so if you guys could follow the marshal to the back, and I will come back and formally excuse you from jury duty.
All rise for the jury.
Okay, this matter is going to be referred to the Division of Probation, set down for sentencing on,
January 8th at 9 a.m.
all right?
Thank you.
Thank you.
And I'm gonna go back and talk to the jury, and the least that they desire to speak to you guys, I'll come back. It's late, I'm gonna talk to you guys.